Hi, and welcome to another edition of the Trustcast Show. And really happy to have with us this morning Amy Mariani. Welcome to the show, Amy.
Thank you. It's great to be here.
So, Amy spent 20 years as a trial attorney. She argued a case before the highest court in Massachusetts, made partner at a nationally recognized firm, and then walked away from it all to become the person in the room that neither side hired. She's now a full-time mediator and arbitrator, and attorneys across the country keep sending her their toughest cases. So, Amy, you argued a case of first impression before the Supreme Judicial Court of Massachusetts. Boy, that's a mouthful. While
It is.
American Airlines. And then a few years later, you left trial law entirely to become a neutral. What was it that kind of prompted that change?
My kids went to kindergarten, and I started thinking about what do I want to do when they're no longer in the house. My husband and I love traveling and have always talked about living in places for, 6 or 8 weeks at a time. You can't do that when you're trying cases because the trial court tells you what your schedule is.
So you spent two decades fighting to win for one side. What was it like the first time you sat down in the middle and can't root for anyone?
That's a great question. One of the toughest things about becoming a mediator or an arbitrator after having tried cases is you have a natural instinct to prepare an argument on both sides of the case. And you have to learn to rewire your brain to have what you're saying to both parties not sound argumentative, but rather sound helpful and like it's going to advance the positions of both sides in terms of their negotiations rather than their arguments. So it really does take rewiring. And I was really bad at it the first 2 or 3 times I did those simulated exercises.
So when you decided to do this, how did that all work? I mean, as far as say, okay, I'm gonna become a mediator, arbitrator. Boom, I'm putting up my shingle, and I'm no longer taking cases. I'm out there talking to other attorneys. Hey, would you like me to arbitrate? How did that all work? What was the mechanics of that taking place?
It didn't happen at the drop of a dime. My youngest went off to kindergarten in 2011 timeframe. And I started thinking about, okay, how do I make a transition to doing something else? First of all, what is it that I want to do? And that's when I thought mediation and arbitration could be interesting. So I got trained in 2012. And then I started doing some volunteer work in 2013 to really test whether this is truly what I wanted to do. Fell in love with it, and my partner and I decided to close down our law firm in 2016 for a wide variety of factors, technology and changes in the industry being one of them. And so my time frame of starting when my kids went off to college in 2023, 2022 time frame was accelerated by a few years, but it actually worked out beautifully because I was then able to spend more time with them in their middle school and high school years.
Hmm. So when you started, just going back to the very beginning. So what made you close your law firm? I mean, we're rehashing old history, but it's just kind of interesting to kind of follow someone along how they ended up where they are.
Sure. Yeah. A lot of changes had happened in the industry during the 5 year window where I was sort of making that decision about what my next steps were. My partner and I ran a boutique litigation firm that represented Fortune 250 companies. And there were tremendous shifts in the way the legal market was structured at that point in time due to technological changes, due to the availability of attorneys from overseas doing a lot of the work that made our firm price competitive. And that was really our biggest advantage is we had extremely skilled attorneys at much lower price points than the firms that otherwise would be competing for that work. When that cost differential went away, it made us a lot harder to land work because other firms were able to sort of package national deals that we
Yep.
simply couldn't do because of our size.
Right. So you said resolution is the real client in mediation. What does that actually mean when the two sides are screaming at each other?
It means keep calm and carry on. Take a nice deep breath and remember that at the end of the day, the goal is for both sides to walk away with a future that perhaps did not look realistic at the beginning of the day. As I said, my real goal is to get the parties to be able to move forward beyond their conflict, because having tried cases that last 7, 8, 9, 10 years, I know how taxing it can be on either side to have to go through a case like that. It's no fun, it's extremely expensive, and it's generally not the best way to proceed. So if I can be the voice in the room that helps the parties remember what the alternatives are to fighting, then that really helps them make better decisions. If at the end of the day they choose to continue on with the fight, that's their choice, and that is 100% within their control. But if I can help them understand realistically what the potential is for the various outcomes in front of them, that's my key advantage.
So, are you, in a way, kind of making the argument for resolving the process without going into the court system? So, in when you're going to court, then you're making the argument to within the court or prior to court to you're making your argument on behalf of your client, but in essence. The resolution itself becomes your client. Is that
Yeah, my goal is basically to have the parties do one of two things at the end of the day: either reach a resolution where they're able to move forward, or realize that yes, there is something that is more important than anything else about going forward, and understand the risks of going forward. So I will talk a lot with the parties about the time involved, the expense involved, the stress involved, the lost opportunities involved in proceeding on with litigation. Those are things that people often don't think about, because you're in a conflict, you go into your lawyer's office for the first time and you start talking about it, and you're all energized about making sure that you get what is yours, you get
Mhm.
what is just, the right thing is done. But you don't necessarily, in those initial conversations, or even, quite frankly, over the period of the next year or two, talk about what the real cost is to you of doing that.
Right. So when you are um, organizing, or so, how do you end up being brought into as a mediator? Who is it that brings you in, and how do they agree upon this you as a singular entity, or so the name of your firm is.
Mariani Mediation, yes.
Okay. So Mariani Mediation. So how do they come to an agreement? Okay, we wanna hire Amy and her firm to help us with this issue. Who decides that?
It's typically the lawyers. Almost all of the cases that I'm involved in are either in litigation or about to go to litigation. And lawyers are involved generally in sophisticated employment, personal injury, or business disputes. So, people identify that they've got a problem. They identify that they need a lawyer to help them solve the problem. The lawyer takes a look at the problem and either initially or at some point in the litigation process says, you know what? It's in my client's best interests to really take a hard look at settlement. That's typically when the two lawyers will agree upon who they want to use as a mediator, in consultation with their clients, of course. And then that's when I get the phone call saying, when are your next dates?
So if you get a phone call, who is it that makes the phone call to you? And how involved does a impartial, like a judge or something like that, involved in that process of deciding what's going to happen here with the mediation?
Sometimes judges will order parties to go to mediation, but typically it's the parties themselves and their lawyers that decide it's time to see if we can resolve this. That usually comes at one of two or three inflection points in a case, or when a client realizes, wow, this is a lot more money than I'd planned on spending, or this is just for some other reason I need to dispose of this. Perhaps it's a business that's looking to to be acquired or to acquire someone else, and it's not going to be possible to do that while there's litigation process. So typically, it happens when someone realizes we're stuck and we need to move forward, and we're not capable of doing that on their own. The lawyers will pick up the phone. I'll talk to them about what the type of case is, make a determination as to whether or not it's the right kind of case for me. If it isn't, I may make some recommendations as to who else they can talk to, and then we take it from there.
What is the right kind of case for you?
Employment, personal injury, and business cases are the typical cases that I handle. So, in the employment area, discrimination and harassment claims, breach of employment contract, things like covenants not to compete, compensation claims, wage and hour matters. In the personal injury side, it's usually wrongful death or product liability cases. And in the business side of things, it's breach of contract, and then a lot of business divorces, believe it or not. So when two partners who've built something together reach a point where they realize they can't work together, they often call me in.
So that's, a broad spectrum of cases. How do you have manage the expertise, or how much of this is a legal argument versus a logical conversation between human beings?
That's a great question. And there are many cases where my past background as an attorney and what I did can be really helpful in talking to the parties about the strengths and weaknesses of the various arguments that they're making. Not that I'm saying to one side or the other, you've got a really good case or you don't, but I can speak more cogently to what the other side is saying and why a judge or a jury may find that to be a credible argument. So that's very helpful. Is it essential that I have a fundamental knowledge of the law in question? No. Do I feel like the parties probably benefit when I do? Yes.
So, who pays you? Is it split between the two attorneys? Is that how that works? And then, is it an hourly thing, or is it a set amount based upon the type or is it both?
It's typically a daily rate, and it is typically split between the parties. The parties, however, can agree to a different way of sharing the fees. Sometimes one side will say, and this is very common in either a consumer based arbitration in particular, where the company will say to the consumer, will pay for the arbitration fees. In a mediation, it's very common for the employer to say, I'll pick up the fees. It could be part of the contract between the parties. So that's a very typical way of proceeding is on that daily basis. And in my daily rate, there's a set number of hours that I say I will provide of prep time and after the session time, and then the session itself. And typically, it's the lawyers who will forward the fee on behalf of their clients, and then they get reimbursed by their clients.
And how do you? So there's the business side of this. There's the whole idea of doing this, but then there's the business side. How do you bring in new clients, and how do you ensure that you have a regular flow? Because just like anything, people think, okay, well, we'll just hire a mediator, but there's also, you've got to have a regular flow of new clients coming in, or things are turned bleak quickly. So how do you handle that part of it?
Networking, and more networking. I actually have on my calendar a dedicated number of hours per month, a minimum that I target. And in months where I have a little less work, I just up the networking. And if I do a certain number of hours per month, I tend to have a fairly steady pipeline. The work that I do for arbitrations tends to come in through the American Arbitration Association. So that's a little different, and that sort of keeps a constant and steady background for me in terms of what I have in my billings. But the mediation work is It's generally word of mouth, and it's generally a question of making sure I'm out there networking, and then doing things like posting very regularly on LinkedIn. Because if someone's sending around an email around their office going, I have this case and I need a mediator, if their colleague has just seen my LinkedIn post a day or two ago, the
Hmm.
chances are much greater that my name is going to get tossed into that ring.
So let's do some rapid fire to kind of break things up a little bit. I like to do rapid fire in there. So Notre Dame football, first game you ever saw at the stadium.
First game was Notre Dame, Michigan, and it was the game where Rocket Ismail ran back a touchdown. First night game ever at Notre Dame Stadium.
Okay. Best truffle pasta you ever had. Was it really in Venice?
It was Ristorante da Ivo in Venice, and bring your wallet, but it is well worth it.
What position did you coach on the boys' squirt hockey team?
I generally ran the offensive door because my son was playing defense, and it was not a good thing for me to be coaching him directly.
Boston sports, which team gets your loudest cheers?
Oh, it really depends on the season. It really does. I'm a passionate football, basketball, hockey fan. Baseball, I get into it when it's pennant season, but it's a lot of games to be watching.
So, do you ever binge watch on Larry Bird old clips on social
Oh,
media?
Larry Bird, that's my childhood. Larry Bird, Magic Johnson, you show me those Lakers Celtics series and I'm in heaven.
So, two dogs at home, what's their names?
Brady and Jenny, short for Genevieve, named after, I don't know if you've ever read the book Madeline or Madeline's Rescue, the
Yeah,
children's books. Yep.
I am familiar with Madeline, believe it or not. So,
Yep.
last great book you couldn't put down.
Oh my goodness. That's a really good one. I just finished the latest in the Camel Club series by David Baldacci, which was a page turner called the Hell's Club, I believe it was.
Yeah, I've read quite a few of David Baldacci's books. So for our audience edification, explain the difference between mediation and arbitration. Actually, we have a lot of lawyers, so some of them are just going to say, "Oh," they roll their eyes and they're going to say, "Why are you asking such a banal question?" But for those
Yeah,
that
no, there are a lot
aren't,
of people who don't. Yeah, a lot of people don't know what it is. Mediation basically is when a neutral party like myself comes in and helps the parties reach a solution on their own. So the agreement that the parties reach at the end of the day is 100% in their control. Arbitration is when I serve as a private judge and I come in and essentially act like a judge would in a courtroom and say someone wins and someone loses. So there's a tremendous amount of control to be had by the parties in a mediation session versus in an arbitration session, where I'm literally going to say at the end of the day, this party wins, this party loses, this party pays this amount of money to the other side. In mediation, the parties can decide who's paying whom, and if so, how much. And they can also talk about things that are separate and apart from the money involved.
so if you're doing arbitration, it seems like there's a higher level of expertise that has to be brought. Is there some sort of do you generally have to be an attorney to or a lawyer to be to handle arbitration cases?
It's rare that you have a non-lawyer arbitrator involved. And typically, if you do, it's on a panel where at least one other member of the panel is an attorney, because there are some legally related things that have to happen in order to make an arbitration award enforceable. So if you don't already have legal knowledge, you're either going to have to get really specialized training, or it's much easier if you actually are a lawyer who is practiced in that particular subject matter.
What percentage of your business is mediation versus arbitration?
About 60-40 at this point, mediation to arbitration.
Okay. So you taught mediation as an adjunct faculty at New England Law. What's the one thing you wish every new lawyer understood about dispute resolution?
There is no such thing as too early. Whenever you are in a situation where you see a conflict coming, getting a neutral party involved to help the parties have that conversation that they need to have is really, really helpful. And there are different professionals at different stages of a conflict who really can make a difference. So if I get a call from somebody, for example, who says, I'm having a problem with my partner, we really want to work it out, I'm going to refer that out to somebody who has a little bit more of a coaching background than I
Mm-hmm.
do and who can help them learn how to work together and communicate more effectively. But as I said, there is no stage of a conflict that's really too early to get some help.
So you served as past president of the MCLE Board of Trustees. How did that shape how you think about training the next generation of attorneys?
Oh, great question. I was involved with MCLE for a very long time on the board, and it was
And
during the period of
for our audience that doesn't know what MCLE, well, what does that stand for?
Sure. In this case, it's Massachusetts Continuing Legal Education. Commonly across the country, it's known as mandatory continuing legal education. And in most jurisdictions, you need to have a certain number of continuing legal education hours to maintain your law license. So it's a really critical part of the legal profession.
So back to my question, how did that shape how you think about training the next generation of attorneys, or did it?
It did. As I was on the board, there was a tremendous influx of attorneys who had been trained on technology really in junior high school and high school in a
Mm-hmm.
way that my generation hadn't been. So the desire for online learning, the desire for remote learning, the desire for webinars, and all of those things, very different from when I graduated from law school, and the expectation was you would go to a weekend seminar and get all of your CLE hours in there. So figuring out how to meet the consumer, meet the lawyers, the new lawyers where they were in terms of how they wanted to consume content was enormously helpful. It really taught me about social media and about learning educational technology in a way that I probably wouldn't have been exposed to.
Mm-hmm. So your ideal case as an attorney is, or is an attorney with a trial date of 18 months out. Why is that the sweet spot?
Typically, when the parties are reaching a phase of the case known as summary judgment, that's after the parties have exchanged information, know enough about each other's cases to really not question, am I going to get a raw deal because I don't know enough about this situation? So everyone is really fully informed about what the facts are, and they understand that the next 18 months are going to be incredibly expensive, incredibly stressful, and incredibly time consuming. So that usually is an opportune place where both sides are very motivated and have the information that they need to make informed decisions.
So that almost counters. I would have to take the that almost counters the idea of being too early, or the says it you had indicated before that it's never too early. Can it sometimes be too early though? So like if both sides don't understand what the other side is, what's the big beef, where they come into it and they're just fisticuffs and they're really not understanding what the other side is what the real complaint is.
There are sweet spots on both ends. So if you get in there early enough, you have not reached that level of emotional reaction, emotional responsiveness, where you're going to get to that fisticuffs, we're going to fight, I need to know every detail kind of stage. If you're in there early enough, there's still a little bit of trust. There's still a little bit of willingness to engage with one another. And you can usually cut something off at the pass there and make sure that you don't end up with a big involved conflict at that stage. So you can save parties literally hundreds of thousands of dollars by getting in there early and getting them to agree early to a resolution. Down the line, they may have a little bit more information, probably not much more, but they will have more information, but they've become entrenched. It becomes a little bit more difficult to unwind all of the stuff, the baggage. But it's important that people think at various points in time, is there an opportunity here for resolution? I personally think the earlier the better. But in terms of the way most people function, they're going to want more information. There's a way to solve that, however.
I like that answer. It's kind of illustrative. So you handle everything from multi-million dollar business breakups to neighbors who can't get along. Which type of case is harder to settle?
The greater the emotion, the greater the feeling that it's a matter of principle. I like to talk about the three P's: power, punishment, and principle. Those are the three things that are really huge obstacles to resolving any matter. If the case truly is a matter of principle, if it's a case of first impression, for example, that case may need to be tried. If it's a question of power or punishment, where one side really wants to make the other suffer for whatever the reason happens to be, you've got your work cut out for you. You can
Hmm.
explain to both sides why continuing down the path that they're on may not be in their best interests. But at the end of the day, if the emotion is still what controls, it's going to be really challenging to get that case resolved. So, I've seen cases where people have literally been fighting over $50, $100 when I've mediated as a volunteer in small claims court, and it is brutal, the level of animosity in those rooms. The bigger cases, even though there's a lot of money at stake, oftentimes it's about the money and not about the feelings, uh,
Hmm.
or more so about the money than it is about the feelings. So you can bridge that gap sometimes a little bit more easily.
So that's kind of interesting. I don't know. As I've gotten older, it's about the principle has kind of fallen by the wayside more than when I was younger. Everything was about the principle. As I gotten older, I don't know. I think I'm wiser, maybe not, but I don't know. Does some of that have to do with the maturity of the sides?
In some respects, I think yes, because the more you've seen of life, generally speaking, the more you know what it's going to take out of you to pursue this particular conflict because you think somebody needs to pay or because you think you've been treated unfairly. You're able to assess in a much different way how important this is to you and to your long term sanity, quite frankly, in many cases.
So, do you ever go into a some sort of mediation, and you feel like you're almost there, and then things just go south over one little issue? Tell me about any scenario that you can think of like that that you could actually openly discuss. I think it's really interesting to translate these into not just theory, but into a real case that happened.
One very common scenario is in employment cases where the parties will agree on the number, but then at the end of the day, something like a neutral reference, the person who used to be the employee wants the employer to say, I was a terrific employee. The employer is not willing to do that. So the everything else could be agreed upon, but they can't agree on what the employer will say when a potential employer for this individual calls. So things like that can be a real headache. And what I love to do is cut those things off at the pass before the mediation even starts by asking both sides what terms are going to be really important to you to get this resolved. And let's make sure we're ready to talk about them at the beginning of the mediation, or you've agreed about them before we even enter the mediation room. Standard language in a settlement agreement, that's another place. So, there are confidentiality provisions, there are non disclosure provisions, there are, you know, tax withholdings provisions, all sorts of stuff like that in settlement agreements. And if the parties haven't agreed upon those things before the number is agreed upon, that's a place where a deal can very easily blow up. So I like to get all that sort of boilerplate
Mm-hmm.
discussed and agreed upon before we even walk into the mediation room.
So, I mean, you have to build rapport, obviously, when you're in in those meetings. So you try to get just understand how the process works. So you try to deal with some of the toughest. I'm having a real tongue tied today. So you try to deal with some of the toughest issues before you actually even go in the room.
I try to get the lawyers to agree on those things because typically at the end of the day, it's the lawyers who are going to be disputing the language, exactly how this particular clause reads, rather than the parties themselves. Most times the parties are really interested in that ultimate number or, maybe one or two other terms that are important. But the boilerplate language, that's where the lawyers dig in and the lawyers can really go to battle. So I like to have them exchange draft documents ahead of time so that there are no surprises and we're not derailed by something like that at the end of the day.
So when you're working with the attorneys, lawyers in the process, there's less emotion involved on that process. But do you ever have a lawyer who gets emotionally charged up about his client's issue, and you can't, and that can be a big issue in the process?
Definitely. There are a lot of times when lawyers develop very close personal relationships with their clients over a period of years. Think of a personal injury case where you've seen this person and the impact that this injury has had on their lives. Think about an employment case where there are allegations of terrible discrimination or
Hmm.
harassment. It's very common in those circumstances for personal connections to form between and I don't mean friendships or relationships outside of the office, but the lawyer learns things, very intimate things about their client that the general public doesn't know, and that creates a natural bond between the two.
Yeah, I see that when I do this podcast sometimes. So you've been named Massachusetts super lawyer in ADR every year since 2017. At this point, what are you still trying to prove?
I'm trying to prove that every dispute can be resolved if people are willing to work at it.
So, if you could change one thing about the legal system and how it handles disputes, what would it be?
Oh, that's a great question. And I think my answer would be that everyone should have an opportunity early on in the case to sit down and have face to face discussions about what it really means to go through this process, what it really means to be in litigation, and what are you giving up by entering the system before you've given resolution a shot.
So, what's the one thing you tell someone sitting at home right now who's stuck in a dispute and doesn't know where to start?
Reach out to me, to someone else who has conflict resolution skills, and we can direct you to a resource that is going to help you figure out how to get through your conflict as opposed to stay stuck in it.
Okay, so where can people find you if they say, "Oh, that Amy, she sounds terrific. I need help on my dispute." Where do they, if they want to reach out and find you? What's the best way?
The best place to start is my website, which is marianimediation.com. That has my phone number and my email contact on there as well. It's much easier to reach out to me either through the website contact form or through my email, which is amariani@marianimediation.com. When I'm mediating, it's really hard to pick up the phone, and it can be, 24 hours or more before I'm able to get back to people by phone. I can usually sneak out a quick email between conference rooms.
Oh, thanks, Amy. Thanks for coming on the podcast. I enjoyed it.
Thank you so much. This was great.
Hi, and welcome to another edition of the Trustcast Show. And I'm really happy to have with us this morning Amy Mariani. Welcome to the show, Amy.
Thank you so much. It's great to be here.
So, Amy spent 20 years as a trial attorney. She argued a case before the highest court in Massachusetts, made partner at a nationally recognized firm, and then walked away from it all to become the person in the room that neither side hired. She's a full-time mediator and arbitrator, and attorneys across the country keep sending her their toughest cases. So you argued a case before first impression before the Judicial Court of Massachusetts while representing American Airlines. And then a few years later, you left trial law completely to become a neutral. What happened in that period of time that made you come to that decision?
My kids went to kindergarten, and I started thinking about, what do I want to be doing when my kids are no longer in the house? I'm a long range planner, and, so I always have that 5 year, 10 year, 15 year thing going on.
So
And when
hang
my
on
kids
just one
started,
second, Amy. So
sure.
I'm going to start over again because I forgot to turn on echo cancellation, and if I don't do that, sometimes it just not always, but sometimes it will act up, and then the if I don't do it, and my